I need you to stop what you are doing right now because in the next few minutes, I am going to walk you through something that the evening news mentioned once, gave you 30 seconds of context on, and then moved on from as if the details did not matter, as if you did not deserve to understand exactly what changed, exactly what you are now entitled to, and exactly what you need to do before certain windows close and certain protections become unavailable to you permanently. What I am talking about is Senate Bill 2184, the Senior Fraud Protection Act, a piece of federal legislation that has just become law, and that if you are over 60, if you are living on Social Security, if you have Medicare, if you own a home, if you have ever come close to falling for a scam or watched someone you love lose their savings to one, this law was written for you. And the reason I am making this video is not to give you a headline. It is to give you every single thing inside that headline that the headline left out, because that is where the money is, that is where the protection is, and that is where the deadlines are that you absolutely cannot miss. Let me tell you something before we go any further. I have spent years working in senior benefits advocacy, sitting at kitchen tables with men and women in their 60s, 70s, and 80s who were not confused because they were not smart enough to understand the system. They were confused because the system was never designed to explain itself to them. They received a letter from Medicare and did not know if it required action. They got a call from someone claiming to be from Social Security and did not know whether to trust it. They signed a document about their home without realizing what they had given away. And almost every single time, the thing that cost them, the thing that hurt them, was not malice on their part and not stupidity. It was a gap in information that nobody had ever filled. Today, we are going to fill that gap completely. So stay with me because what comes later in this video, the piece I am calling the single most overlooked protection that most seniors never activate, could be the most financially important thing you hear this year. But first, let me build the full picture because context is everything. For decades, the financial predators who target older Americans have operated in an environment that was, frankly, almost designed in their favor. Every year, seniors across this country lose an estimated $36 billion to financial fraud and exploitation. Not to bad luck, not to the stock market, to deliberate, calculated, organized criminal activity specifically engineered to exploit the trust, the isolation, the fixed incomes, and the unfamiliarity with rapidly evolving digital deception that characterizes the lives of so many people over 60. And the federal response for all of those decades was scattered. It was underfunded. It was reactive rather than preventive. Cases were filed and forgotten. Victims waited years for restitution that often never came, and the criminals adapted faster than the enforcement infrastructure could follow. Senate Bill 2184 represents the most serious, most comprehensive, and most financially committed effort the federal government has ever made to change that reality. And I want to walk you through every major provision because each one has something in it that is directly relevant to your daily life, your financial safety, and your peace of mind. The first and perhaps most immediately impactful change this law creates is a dedicated, permanent federal funding stream of $400 million annually directed exclusively towards senior fraud prevention, investigation, prosecution, and this is the word I want you to hold on to, recovery. Not investigation alone, recovery. This fund cannot be redirected. It cannot be repurposed in the next budget cycle when another priority emerges. It is written into the law as a permanent protected appropriation, which means it will still be there 5 years from now, 10 years from now, funding the infrastructure that keeps you safe. In practical terms, that money is hiring 500 new specialized fraud investigators across the Federal Trade Commission, the FBI, and the Department of Justice. Investigators whose entire job description, whose entire caseload is elder financial fraud and nothing else. It is also creating 37 new senior fraud rapid response units distributed across every federal judicial circuit, which means that when a fraud complaint comes in from someone in rural Kansas or suburban Florida, there is now a trained, funded unit that can respond within 72 hours rather than adding the case to a queue that may not be reviewed for months. But the piece of this first major change that I think will mean the most to the people who have already been hurt or who know someone who has is the Victim Recovery Fund. Embedded inside Senate Bill 2184 is a provision that allows a court, upon the conviction of someone who specifically targeted a senior in a financial fraud scheme, to order restitution from a federal victim recovery fund before that perpetrator's own assets are liquidated. Think about what that means in practice. Right now, if a senior loses $30,000 to a romance scam and the perpetrator is eventually caught, tried, and convicted, a process that can take 3 to 7 years, that victim then has to wait for the perpetrator to actually pay the restitution that was ordered, which frequently never fully happens because the criminal has already spent the money or hidden the assets. Under this new law, verified victims over 65 can apply for interim recovery from the federal fund while the criminal case is still proceeding. The money comes back to the person it was stolen from, not eventually, not conditionally. As a verified victim, you can begin the recovery process while justice is still being served. I want to tell you about a woman I will call Eleanor. Eleanor is 71 years old. She is a retired school librarian from a small town in Tennessee, and 2 years ago, she lost $42,000 to a man she had been communicating with online for 8 months, a man who she genuinely believed was a widowed engineer working overseas who was coming home to meet her, who needed just a little financial help to clear customs paperwork before his flight. By the time Eleanor's daughter helped her understand what had happened, the money was gone. Eleanor's savings were gone, and the sense of shame she carried, the feeling that she had been foolish, that she had let herself be used, that she had somehow failed her own family by losing what she had worked 40 years to build. That shame was in some ways more devastating than the financial loss itself. Eleanor is not behind you in this video. She is in front of you because Eleanor's story is the reason this law was written. And the recovery fund provision means that people in Eleanor's exact situation going forward do not have to choose between pursuing justice and rebuilding their financial lives. They can do both at the same time, with federal support behind them. The second major change addresses what security professionals have long identified as one of the most dangerous vulnerabilities in the financial lives of older Americans: the Social Security number security gap. Your Social Security number is, for practical purposes, the master key to your financial identity. It appears in more systems, more databases, more transactions than at any other point in American history. And for seniors, particularly those who do not regularly monitor their credit or check their accounts online, the window between when that number is compromised and when the damage is discovered can stretch into months or even years. During that window, new credit accounts are opened in your name. Tax refunds are redirected. Medicare benefits are claimed by identity thieves billing for procedures you never received. Senate Bill 2184 creates the first mandatory real-time senior identity alert system in federal law. The Social Security Administration will now cross-reference every Social Security number belonging to a person 62 or older against a database of known fraud indicators and suspicious activity patterns on a daily basis. When a flag is detected, an alert goes directly to the senior's registered contact within 24 hours. Not to a credit bureau, not to a collection agency, not to a system that will process it 6 months from now when the damage is irreversible. To you, within 1 day. For this to work, you need to have a My Social Security account at ssa.gov. If you do not have one, creating one this week is one of the most concrete, most immediately impactful steps you can take for your own financial safety. If you are not comfortable setting one up online, Senate Bill 2184 has funded free in-person assisted setup sessions at every Social Security field office and every participating public library across the country. Walk in with your Social Security card and a photo ID. A trained assistant will set up your account, register a trusted contact of your choosing, and activate your alert preferences at absolutely no cost to you. This is a service you have already paid for. Go use it. The third major change creates the first unified national standard for how banks, credit unions, brokerages, and any financial institution holding accounts belonging to customers 62 or older must behave when suspected exploitation is detected. For years, financial institutions occupied a uniquely powerful position in the fraud protection landscape. They were often the first place where fraud became visible, but they operated under a patchwork of voluntary guidelines and inconsistent state rules that gave them enormous discretion to do very little. That changes now. Under Senate Bill 2184, every qualifying institution must designate a senior account protection officer at every branch, must implement written protocols for handling suspected exploitation, including specific hold procedures and reporting timelines, and must file a suspicious activity report within 48 hours of detecting a transaction pattern consistent with elder financial exploitation, while simultaneously notifying the account holder directly, not waiting for the account holder to call in, reaching out proactively. And critically, the law creates real financial liability for institutions that fail to follow these protocols. If a bank failed to follow the required standards and a senior suffered documented losses as a result, that institution can now be held financially responsible for a portion of those losses. The incentive structure has fundamentally changed, and the change is in your favor. Here is what I want you to do within the next 90 days because of this provision. Call your bank or credit union and ask 3 specific questions. Who is your designated senior account protection officer? What is the transaction alert threshold for accounts like mine? And how do I formally register a trusted contact so that if a suspicious transaction is detected, you have someone to call immediately? Those 3 questions take 10 minutes on the phone and create a documented record of your engagement that can be genuinely valuable if you ever find yourself in a dispute about how a potential exploitation situation was handled. Now I want to pause for a moment and connect with you directly, because I know that some of you are watching this video in the middle of a situation, not a hypothetical one, not a future one, but one that is happening right now. Maybe you have been receiving calls from someone claiming to represent a government agency. Maybe you have noticed charges on your Medicare explanation of benefits that you do not recognize. Maybe you have a parent whose finances you are trying to protect and you do not know where to start. If that is you, I want you to comment below right now and tell me your age and the specific concern that is weighing on you most. Is it prescription costs, medical bills, a scam you are worried about, a Medicare charge that does not look right? Write it below. I read every single comment, and the patterns I see in those comments shape exactly what I create next. And if this video is giving you something real and useful, please take 2 seconds to click the like button. It is how YouTube knows to put this information in front of the seniors who need it most. And subscribe to this channel, because the most important thing I am going to share today is coming up very shortly. And it is something I genuinely believe most people over 60 have never heard explained this way. Stay with me. The 4th major change in Senate Bill 2184 creates something that has never existed before in federal criminal law, a standalone criminal offense specifically targeting what the bill calls elder emotional manipulation fraud. This addresses what the FBI has identified as the fastest growing and most psychologically devastating form of elder financial crime. The deliberate cultivation of romantic or deeply personal relationships with older adults for the express purpose of financial exploitation. Right now, perpetrators of romance scams are charged under general wire fraud statutes with penalties that bear no relationship to the specific cruelty of what they did. Of finding a grieving widow, spending months building her trust, using her loneliness as a tool, and then systematically emptying her savings. Senate Bill 2184 creates a new federal statute that explicitly criminalizes this category of conduct and attaches enhanced penalties when the amount stolen exceeds $25,000, when the victim was living alone, when the perpetrator specifically targeted grief or loneliness as the mechanism of manipulation, or when the victim suffered documented psychological harm in addition to financial loss. The enhanced penalties increase the minimum federal sentence by up to 50% above the standard fraud baseline. This is not just a legal shift, it is a moral declaration. For the first time, federal law says explicitly, targeting a lonely senior with a manufactured relationship is not a financial crime with emotional side effects. It is a distinct, more serious category of predatory conduct, and it will be treated accordingly. The 5th major change concerns Medicare fraud. And I want to spend some time here because the Medicare dimension of this law has implications for you whether or not you have ever suspected fraud on your account. Medicare fraud is simultaneously one of the largest drivers of waste in the federal healthcare system and one of the most direct ways that seniors are personally harmed, not just as potential victims of identity theft, but as beneficiaries who lose access to legitimate care they genuinely need because fraudulent billing has exhausted their coverage limits. Senate Bill 2184 allocates $120 million specifically to Medicare fraud detection, including the deployment of artificial intelligence monitoring systems capable of identifying suspicious billing patterns within days rather than the months or years that manual review processes currently require. But the provision that most directly affects you personally is the new Medicare Fraud Victim Recovery Program. If your Medicare number was used to bill for services you did not receive, and you subsequently lost coverage for services you did legitimately need because your benefit limits were exhausted by that fraudulent billing, you can now file a formal recovery claim. That claim will be processed within 60 days and can result in full restoration of your benefit access plus an additional credit toward future covered services. Here is the action step. Go through your Medicare explanation of benefit statements from the past 12 months. Look for any charge for a service, procedure, or equipment that you do not remember receiving. Every single one of those unfamiliar charges is a potential recovery claim. Start a file. Keep every EOB statement that shows something that does not look right. Call Medicare directly at 1-800-633-4227. That is the official number, the one you look up yourself and dial yourself, and report what you found. Under the new recovery program, the process for what was previously an almost impossibly bureaucratic claims journey has been streamlined into a 60-day resolution window. That is a genuine, meaningful change. I want to tell you about a man I will call Raymond. Raymond is 68 years old, a retired postal worker from Michigan who had a knee replacement 18 months ago. About 6 weeks after his surgery, he received a Medicare explanation of benefits showing charges for physical therapy sessions that he had never attended at a clinic in a city he had never visited, billed under his Medicare number. Raymond almost threw the document away. He thought it was junk mail. His granddaughter happened to be visiting that afternoon and stopped him. Together, they called Medicare and filed a report. 14 months later, after the fraudulent billing had been traced to a larger criminal operation, Raymond received a letter confirming that his Medicare benefits had been fully restored, along with a credit toward future services. Raymond told me, "I almost didn't say anything because I thought it was too small for anyone to care about. It was not small. It was his coverage." And under Senate Bill 2184, the system is now designed to take it as seriously as he deserved. The sixth major change addresses what the law specifically calls the Senior Housing Fraud Protection Provisions, and these matter enormously at a moment when reverse mortgage fraud, predatory home repair schemes, fraudulent property deed transfers, and deceptive senior living facility contracts are devastating families across every state in the country. Senate Bill 2184 creates 3 new federal protections for seniors in housing transactions. First, a mandatory 3-day cooling-off period for any financial transaction involving the primary residence of a person 65 or older, during which the transaction cannot be finalized, and the senior must receive written notification of their right to rescind. Second, mandatory independent legal review, paid for by the institution or party seeking to complete the transaction, not by the senior, for any deed transfer or reverse mortgage involving a senior account holder. And third, a new federal certification requirement for any organization marketing housing services or housing transitions to seniors, with loss of certification and prohibition from federal program participation for any organization found to have engaged in deceptive practices. If you or someone you love is approaching any kind of decision about a home, a reverse mortgage, a transition to an assisted living facility, a deed transfer, a major repair contract, these 3 provisions create a buffer of protection that did not exist before this law was signed. And now, the provision I promised you, the one that I genuinely believe is the most overlooked, the most underutilized, and the most immediately valuable protection that Senate Bill 2184 creates. It is called the National Senior Fraud Registry. And while some of the other provisions in this law work automatically in the background, this one only works if you activate it yourself. And most seniors will never know it exists, which is exactly why I am telling you about it right now and exactly why you need to act this week and not someday. The National Senior Fraud Registry is a voluntary opt-in database managed by the Federal Trade Commission. Once you register, your name, social security number, and designated trusted contact are added to a database that financial institutions, telephone carriers, and verified organizations are legally required to check before completing certain categories of high-risk transactions associated with your identity. If your name is in the registry and a high-risk transaction is attempted, additional mandatory verification steps must be completed before that transaction can proceed. It will not stop everything. No single protection can, but it inserts a mandatory human checkpoint into the automated high-volume fraud pipelines that rely on processing stolen personal information faster than any human review can catch it. Registration is free. It takes approximately 15 minutes. It is done at ftc.gov, the official Federal Trade Commission website, and you will need your social security number, your date of birth, and the contact information for one trusted person in your life. Once registered, you will receive a confirmation and a unique registry reference number that you can provide to your bank, your Medicare plan, your credit union, and any other institution where you want the enhanced verification protections to apply. If you are not comfortable registering online, you can call the FTC's Senior Fraud Hotline directly at 1-877-382-4357 and complete the entire registration by phone with a live representative. Do this week, not next month, this week. Because the window in which your registration is most valuable is right now, while this law is new, while the institutions are updating their compliance protocols, and while the criminal networks that will eventually find ways to work around this registry have not yet had time to do so. Before I give you the closing action steps, I have to give you the warning that I consider equally important to everything else in this video. Scammers move fast. Within days of legislation like this being signed into law, criminal organizations are already building scripts around it. Right now, as you watch this, there are people calling seniors across America claiming to be from the FTC, from Medicare, from the Social Security Administration, offering to help register them for the new Senate Bill 2184 protections. Every single one of those calls is a scam. The federal government does not cold call you. It does not reach out to help you register for new programs. Registration for every protection in this law is something you initiate through official websites or official phone numbers that you look up yourself and dial yourself. The real FTC number is 1-877-382-4357. The real Social Security Administration number is 1-800-772-1213. The real Medicare number is 1-800-633-4227. Write those down. Put them somewhere you can find them. And if anyone calls you offering to help with the new senior fraud protections and asks for any personal information, hang up. Call a family member. Call your trusted contact. Report it to the real FTC at the number you just wrote down. I want to close by speaking to something that goes deeper than legislation, because the people watching this video are not just policy recipients. You are not passive beneficiaries waiting for a system to protect you. You are men and women who built careers, raised families, paid taxes, served in the military, held communities together, and arrived at this chapter of life having done everything that was asked of you, and found that the systems designed to support you were often confusing, often inaccessible, and often silent precisely when they should have been loudest. Senate Bill 2184 does not fix everything. I will not tell you that it does, but it is a genuine, serious, well-funded signal from the legislative branch of the federal government that the $36 billion assault on the financial lives of older Americans is no longer going to be met with a shrug and a pamphlet. It is going to be met with investigators, with recovery funds, with real institutional accountability, and with a registry that puts your name on a list that says, this person has rights, and those rights require verification before anything moves forward. You are not behind. You are not too old to protect yourself. You are not too late to activate these protections, to make the calls, to set up the account, to ask your bank the 3 questions, to register with the FTC. Every single step I described in this video is available to you right now, today, as a right. Not a favor, not a benefit that someone can take away, but a legally established right that this law created for you specifically. And the greatest act of self-advocacy you can perform this week is simply to use it. Share this video with every senior in your life who you believe deserves to know what I just told you. Because knowledge, in the world of elder financial fraud, is not just power, it is protection, and you have earned it.